The following are excerpts of testimony heard at the International Court of Settlement of Investment Disputes, or ICSID, World Bank Headquarters, Washington, D.C. in December 2016. Mr. David Aven and others sued Costa Rica for an illegal government shutdown of their $100 million beach homes project. The Republic of Costa Rica accused David Aven of duping Satena, the country's head environmental regulatory agency, but they brought no evidence. Costa Rica failed to produce one witness from Satena or any of their other government agencies. The state only presented their own lawyer's allegation and assertion testimony, which is not evidence.
Look, I didn't dupe anybody. You know, duping the federal government is a very serious crime. Deceiving a government is a very serious crime. And what I would say is this. I still think Satena is a governing, an agency that is still in business in Costa Rica. I haven't heard it close its doors. And when you make a serious charge like that, where is Satena? Where is their statement? Where is somebody, you know, the government could go to, they work for the government. They could go to their office, Satena office, and say, look, we have evidence that David Aven duped you. We want to get a statement from you to confirm that. Isn't that what you do normally when you try to, before you start accusing somebody of serious crimes? Go get your evidence to prove it.
Mark Baker, an arbitrator, asked Mr. Luis Martinez, the Costa Rican criminal prosecutor, a simple question about intent, which must be proven in order to convict someone of a crime. Mr. Martinez had two contradictory government reports, one saying there was wetlands and the other saying no wetlands. So Mr. Baker wants to know how Mr. Martinez could file criminal charges against Mr. Aven with two contradictory reports. Here, Mr. Martinez gives a confusing and strained answer to a simple question. Please note, two contradicting government reports are objective evidence that must be accepted as factual evidence. There was nothing to analyze. A prosecutor's legal duty under law is to accept exculpatory evidence without question. The law is not based on a belief system or a flip of a coin to decide which report to believe. Again, two contradictory reports are objective evidence and must be accepted by a prosecutor without question. There are only two possible explanations for Mr. Martinez's disregard of the rules of procedure to file criminal charges against Mr. Aven. Is he incompetent, corrupt, or both? We report, you decide.
Okay, so now I need your help on the way in which you made your decisions to exercise your discretion as a prosecutor. Help me understand, sir, the thought processes about receiving one report that classifies an area as potentially meeting the definition of wetlands, and then other information that came to light during the investigation showing that other agencies and other reports were prepared saying that there were no wetlands. How did you make a decision resolving that inconsistent information? Did you consult with experts about that, or did you make the decision yourself or in consultation with your boss? How did that come about?
Yes, I understand. In this case, when the final analysis is made to make a decision, that is to issue the requirement, because when the analysis is made, when the final analysis is made, when we're ready, because the investigation at some point we have to conclude it. We cannot have a criminal cause open for years. So when the prosecutor or I considered that there was enough evidence to make a decision, I had to sort of weigh and analyze each one of the reports and make a decision. That decision was made basically bearing in mind what had been written in the reports and what we were able to consult regarding the signatories of these reports on the conditions of the site that they had observed when the report had been issued. So we took into account the report and what the person who had issued the report said, and then with that information, when the evidence for trial is offered, the public prosecutor's office, that is, I offered the report and the person who had prepared it. So the analysis implied observing the document, interviewing the person who had prepared it to find out about the conditions he or she had observed at the point when they had done the visit before preparing the report, and also consider the chronology of the impact that had been documented by a number of institutions, because it said there that it had begun in 2009, in April 2009, as we just saw now, and that it continued for a certain given period of time. So we needed to have an overall vision of the chronology of the impact, the reports that were in the file, when these reports had been prepared, and the visits prior to the preparation of the reports. And we also had to take into account, or we took into account, a more in-depth study that was being carried out by someone from an institution, which is the National Wetlands Program, that they have large and long-lasting experience in that area. So with all of that information, we had to make a decision. We had to decide if we were going to bring charges or if we were going to ask that the file be filed. To a certain extent, we had two positions, but the decision has to be made. And in this case, we weighed, among other things, the precautionary principle that is under our constitution and legal system of environmental protection. In this case, we felt that the final report of the National Wetlands Program was more comprehensive, and the explanation that had been given by the person who had prepared it was more reasonable than the explanations or the reports that had been generated in other times where they said there was no wetlands because they had been carried out through visits at times when already there had been an impact. So with all of these elements, we had to make a decision. And with all the respect, I know you will have to make a decision too, now that there are two positions. And with the information we're providing, you will obviously have to make a decision. So we also had to decide between these two positions. And my line of thought was, or the decision I made was on the basis of that analysis, all the reports, the people who had prepared the reports, and the chronology when these reports had been prepared, all in light of the impact on this site that already had been documented.
Next, Martinez admits that he was the one making all the decisions. Therefore, no one else is responsible for the incompetent or corrupt decisions made here. He was recently put in charge of rooting out corruption in Guanacaste province. Is this like putting a wolf in charge of guarding chickens? We report, you decide.
Thank you for that. Help me with this, because at different times during your answer, you spoke in the first person singular, I, and sometimes you said we. So I'm trying to get a handle on who actually made the decision. Was it you? Did you consult with others and the responsibility was always yours, but you took opinions from others in your office? Help me with that.
Maybe it's just simply a question of language when expressing myself. The decisions on the files that the prosecutor has normally are made by the person who is in charge of the case. In this specific case, the decision was mine.
Mr. Baker again asks Mr. Martinez a very simple question about whether proof of intent is necessary before he can file criminal charges against Mr. Aven. At first, Mr. Martinez's answer seems to be incorrect. Listen carefully and see if his answer makes any more sense the second time he is asked.
Go back through it one more time. Do I understand your testimony to be that of the 110 environmental criminal statutes that you told me about before lunch, that only one of those requires the prosecution to prove intent in order to justify a penal sentence. Is that, do I have that right? And that's intentionally setting a forest fire?
No, es todo lo contrario. Solo uno está previsto.
Interpreter, it's quite the contrary, actually.
I deliberately ask you in this question the other way provocatively, so why don't we just start over and we'll go from there. Number 2. Please, continue. You were about to tell me how my question had it backwards.
Yes, environmental legislation only has one crime where someone can be culpable, and the other 110, if it's not 110, it's close. Let's say it's 110. Well, 109. Well, you can only file charges if there has been criminal intent. And then there's one which is culpable setting a forest fire. In other words, you were negligent and you set a fire, but that is a crime. So it's just to lay it out for you in very simple terms.
My understanding in this case, the prosecution at its trial was going to have to prove that Mr. Aven intentionally destroyed a wetland. Is that correct? In order to support a conviction?
Es correcto.
That is correct. At least for eventual intentionality, which is a kind of criminal intent.
Next, Mr. Nestor Moreira, expert witness and criminal defense attorney in Costa Rica, is asked a similar question about intent from the panel. Compare his answer to Martinez's incomprehensible answers. Mr. Moreira says there was clearly no intent. Therefore, there was no basis for Mr. Martinez to file his criminal charges.
One of the manifestaciones, one of the ways the due process is reflected, let's say, in the criminal proceeding is something that is specifically provided in our procedural criminal code, Código Procesal Penal. We call the principle of objectiveness. And according to the principle of objectiveness, the prosecutors are not only intended to go and prosecute somebody with the version of one of the parties. In this case, with the version of Mr. Buchelato, or with the version of part of the employees of one body, like SINAC. Why part? Because there's still a very strange thing that I don't understand, and that strange thing is that SINAC, the environmental administrative bodies that handle Mr. Aven's permits and requests since, let's say, 2006 or 2007 until 2010, in which all those employees and visits and reports stated that there were no environmental problems in the property, no wetlands, no forests, no nothing, basically no nothing, and relying on those reports, other more powerful in terms of scope reports were granted, like the Setena one. One day, suddenly, because of, according to me, the fear of the director of the ACOPAC, Mr., I think the name, Carlos Vinicio Cordero, appointing Mr. Luis Picado. Luis Picado changed all that technical, so-called technical criterion to suddenly state that there were wetlands and that there was a huge damage to the environment and that there were a lot of irregular things happening in the property. That things happen one day to the other. In the case of the wetlands, for instance, that things happened from August to January. So according to Picao, for instance, there can be a wetland that is born in August and it becomes a wetland in February, in 6 or 7 months before. The thing is that I still don't get the sudden change of technical criterion. I still don't get how the prosecutor didn't understood Mr. Martinez, with all due respect to him. I still don't understand why he didn't pay attention to the fact that while Mr. Aven was getting all those permits, there were specific reports from the environmental agencies from Costa Rica stating that there was no problem. So there is no intent, there is no dolo. There cannot be an intent from Mr. Aven. Why? Because it's not possible for him to represent the possibility of a crime if the bodies, the bodies entitled by the Costa Rican state to say that, said the opposite. So how, you have to be like PhD biologist or a PhD in wetlands to contradict those criterions. And it's not the case. He's a developer and he's an American citizen. He has to rely in two things: in the criterions of the environmental bodies that were consistent during 3 years, and in the criterions of the people he has hired during more than 3 years, like 6 or 7. And all those criterions met in the fact that there was no trouble. So one day, somebody, Mr. Picao, thought that there were wetlands, there were forests, and upon that only version, Mr. Martinez built a criminal case. Upon that only version, Mr. Martinez thought that there was dolo, that there was an intention. How come? How come all those years? Are those going to be erased? Nothing that happened? There were no reports? If there is still a contradiction, because there is still a contradiction, the permits are still valid. This Costa Rican state hasn't promoted the nullification proceedings to nullify those permits. Those permits are still binding and enforced in Costa Rica. And on the other hand, you have criterions that were issued after those permits saying the opposite. So Mr. Martinez never ever pay attention to the fact that there were permits. Mr. Martinez never ever pay attention to the fact that Mr. Aven hired experts.
Next, Mr. Morera explains his most powerful argument against Mr. Martinez's decision to prosecute. There was no evidence or proof of intent.
It was not my most powerful argument. My most powerful argument was the lack of intent, the lack of demonstration of the intent and the disregarding of the objectiveness principle. Yes, a more substantive issue.
Again, is Mr. Martinez incompetent, corrupt, or both? We report, you decide. Next, Mr. Aven clearly explains in detail that Mr. Martinez told him and Mr. Jovan Damianitz that he did not believe the INTA report, which stated there were no wetlands. The law is not based on a belief system.
On May 15th, when the prosecutor, Mr. Martinez, come down to the project site, 2 weeks after the INTA report was gotten to us, I thought we were going down there and I thought we were going to meet Mr. Martinez and he was going to say, look, based upon the INTA report, we can't proceed because now we got think about this, you're attorneys. We got 2 contradictory reports and he's trying to make a claim about accusing me for a crime. Now we got 2 contradictory reports, one from INTA saying there's no wetlands, which counsel said he couldn't understand why they did that. Well, INTA's a professional. I mean, they're the professional organization. So, and then my report said wetlands. How can you proceed with a criminal case against the person when you got two contradictory reports by government agencies that you asked for? I mean, it's mind-boggling. So, but what I wanted to say, I remember asking the prosecutor when he said, then he said he had a group of a team of the Menai people there, and he said, can we borrow some of your guys? We want to go stake out the wetlands. I said, what? Stake out what wetlands? Didn't you read the inter report? And Mr. Martinez said, and it was translated when my attorney was there, and he said, and this is what he said to me: I don't believe that report. Now I want you to think about that statement coming from the mouth of a criminal prosecutor. I don't believe that report. Is the law based on a belief system, or is the law based on facts and evidence? A prosecutor, one that's competent and operating the right way, that's objective evidence. You don't have an option to not believe. You have to believe it. In fact, when we talked to Esau Chavez, Manuel and I was telling him all about this, and I showed him the copy of the April 2nd Menai report that they needed before they cleared the land environmentally. And I said to him, Mr. Chavez, I said, Mr. Chavez, did you get this report? Yeah, we got that. I said, did you believe it? You know what he said? We have to believe it. We have to believe it. We have no choice. But yet, when Mr. Martinez gets a copy from a government agency that he ordered, he says he doesn't believe it.
Mr. Martinez, by not believing objective evidence from a report that he ordered, violated Costa Rican criminal law. Should he be investigated for not obeying government orders and for filing false criminal charges by the Costa Rica Attorney General's office? We report, you decide.
I mean, that's just mind-boggling. Now, I don't mean to belay it, but this is so interesting. So I kept saying to him, he says, he started to, you cut 400 trees. I said, where's the 400 trees we cut? Show them to me. Where are they? I kept insisting. So finally he says, he takes us to the far end of the project. We walk from the end of the project all the way to the road, which was a long way, all the way back. There was nothing there. Nothing. And it was pristine because we weren't even working back there. So I get back to the beginning where we started, and I was so frustrated. And Esteban Bermudez was with me, and Jovan, and I was mad. I says, where's the 400 trees? Where's the 400 trees you said we cut? And so him and Ms. Picardo, they got mad now. They got mad because I was calling them on where's the 400 trees. They go 50 meters into the property, and they go like this. Okay, so Esteban and I walk in, and he points to a tree. It's like this big. And I said, that's a small tree. And here's what he says to me. And to get an idea into the mentality of this guy, he says, well, if you kill a small child, isn't that murder? And I said, are you relating cutting a small tree with killing a child? He says, yes. Now, what are you going to do with this kind of thinking?
Well, I'm going to ask you a different question. That's what I'm going to do.
Okay.
So
Coming up, Mr. Aven accuses Martinez of filing malicious and false criminal charges, knowing there was no intent. He also accuses Mr. Martinez of lying about 400 trees being illegally cut. Not one word of Mr. Aven's 3-hour testimony was objected to or challenged by Costa Rica's attorneys. When Mr. Martinez testified later, he was not asked to refute or rebut any statements made about him by Mr. Aven. Therefore, all of Mr. Aven's testimony stands as being truthful, since he took an oath to tell the truth, and none of his testimony was objected to, rebutted, or even asserted as being false, and certainly not proven false.
And I want you to understand this clearly, because when he came on the scene in 2011, something that you wouldn't see in his chronology, a couple things were happening, and there's a certain situation with respect to the project where it was. In summer of 2010, Mr. Buccellato started making complaints. He's a competitor, so he made a complaint with Satena and other agencies, but Satena. So what's Satena? And Satena and Menai. So what do? Satena and Menai, Satena sends down an inspector to say, okay, we got a complaint. And I'm going to tell you what, Satena absolutely was the proper agency. I never had a minute's problem with them, except one time when they canceled the permit in April. But they came down and did the inspection. They issued the permit. They issued the resolution in September 1st, 2010. They rejected Buccellato's complaint. And now that resolution was another law, another government order that the functionaries and public and private people were required to comply with. Buccellato was a private person. Martinez was a public official. So they reject it, and specifically Buccellato is mentioned in that resolution. So what happens? 5 months later, Buccellato takes his complaint to Martinez, the prosecutor, according to his statement, on February 2nd, I think he says. And he started a complaint. Then 6 days later, he gets a complaint from, I think, Louis Picardo, or vice versa. I'm not sure which come first, but I think it was Buccellato made his complaint on the 2nd, and Picardo makes his complaint on the 8th. Now, think about this. Is that a coincidence that Martinez got those two complaints 6 days apart? And what did Martinez do next? The very thing he said, on the February 8th, he immediately seized the Satena files. Is that a normal reaction? Would you think somebody would call Satena, would call me, would call somebody, talk, say, what's going on here?
Next, Mr. Aven clearly accuses Mr. Martinez of violating Costa Rica law by refusing to comply with a government order from Satena, which he was required to comply with. Mr. Aven clearly states that this rogue prosecutor was the reason a multi-million-dollar lawsuit was filed against Costa Rica, which so far has cost Costa Rica millions of dollars in attorney's fees. The arbitrators are now in deliberations, and an award for the U.S. investors is expected early 2018. Mr. Martinez alone may be responsible for many millions of dollars in damages cost to the government of Costa Rica. As stated before, either Mr. Martinez is the most incompetent prosecutor in Costa Rica, or he is totally corrupt. We report, you decide.
No, he immediately seizes the files, which has to tell you something. So when he seized the files, what did he have to see? He had to see that September 1st resolution that Satena rejected Buccellato's complaint. Now, to me, a competent prosecutor, after seeing the resolution that Satena issued on September 1st, and now Buccellato is making the same complaint to the prosecutor 5 months later, would seem to me a competent prosecutor to say, Mr. Buccellato, you made this complaint to Satena 5 months ago. They ruled on it. They made a determination. They rejected your wetland complaint. So I must tell you something. Do you know by law that you're required to comply with this complaint? You're a private citizen, and you are required to comply with government orders. He didn't tell him that. And he should have said, and I am required to do that too. What did he do? He takes Buccellato's complaints and runs with it. And he refuses to comply with a government order. He could have stopped it right there and then. If he would have let Satena, and Menai would have let Satena just carry out their prime directive in being the agency that was given the authority by the government and the courts as the only agency that has the power to issue these EVs, and they put the force of law behind it to make sure everybody would be required to follow it. And I said in my statement, what the government was trying to do is to stop the dysfunction that's happened in our case that's led us here. So if Mr. Martinez would have just followed the law and complied with his own law, we wouldn't be here.
Thank you, Mr. Chairman. Thank you.
Interpol issued a red notice on Mr. Aven based on a false claim, but canceled it later. The claim was that Mr. Aven was wanted to serve a 3-year prison sentence for an environmental crime, but Mr. Aven was never convicted of a crime. When Costa Rica requested reinstatement of the red notice, Interpol explained in a letter that the red notice did not meet Interpol guidelines. The questions are, did Mr. Martinez know this, and did he trump up a false statement to Interpol? And was Mr. Martinez caught in a lie again, or just grossly incompetent? We report, you decide.
I'll come back to this in a minute, but let me switch gears. You were asked some questions about the Interpol red flag notice. Was that a decision that you made to report Mr. Aven to Interpol by yourself, or was that a decision where you consulted with others in your department?
No, absolutamente no.
Absolutely not. That does not depend on the prosecutor, this decision. And in this specific case, it didn't depend on me. When we began the trial and Mr. Damjanak and Mr. Aven were called upon to come, we were told that they would not appear and that he had come to the United States. At that point, the only decision that the prosecutor could make was to request that the judge of the court enforce a provision in the criminal code, which is called default. And that's when someone does not or cannot be located at their domicile. And so we asked that the defendant be declared in default for having gone to another country and evading justice. So as a result of that request to declare him in default, then the international arrest warrant was issued so that the person who's a fugitive from the country can be captured for purposes of extradition. And that's the only thing that specifically, which depended on me. Now, based thereon, there was a resolution that was issued by an independent judge, a female judge in this case, in which she actually decided to declare him in default and then issue this international arrest warrant. And then there was a whole administrative paperwork trail that went on to inform Interpol authorities about the need to have this person detained at some point. But the office where I work does not intervene in this. Now, my participation in this regard, with regard to the arrest warrant, was to request that the judge do this. She made a decision, and we have an office called OATI, and this specialized office in these kinds of matters begins to do translations into English. They communicate with the corresponding authorities. And thereafter, Interpol decides the kind of alert that would be issued against the person. So I understand this is an Interpol decision, which has its headquarters in Costa Rica. It's a police organization with headquarters in Costa Rica.
Next, Mr. Martinez continues with rambling, duplicitous answers, and we learn he was responsible for the revenge Interpol filing. Truth, like a bell, has a certain ring to it, and the bell that rings when Mr. Martinez is talking does not ring of truth. He falsely states at first that he had nothing to do with the Interpol red notice filed. Then later he admits that he was the one who asked the judge for the Interpol red notice.
That's helpful. I've had more than several occasions to deal with Interpol in my career for clients, so I wanted to make sure that I understood how the system worked in Costa Rica. So my understanding is that when you filed your motion for default, it was assigned to a different judge than the original trial judge, right?
No, esa,
Yes, that resolution was issued by a judge that actually heard the case against Mr. Damjanag. In Quepus, there's only one trial judge, and she decided on that, and then she issued a judgment in the case against Mr. Damjanag, which was then appealed by the prosecutor's office and is still pending trial.
Next phase of this is that once the judge grants the motion for default, the papers are then sent as a matter of course by the judge to someone in the Ministry of Justice or at the Attorney General's office for further processing. What's the next stage of the I know it's not your office, but I'm just trying to figure out how many independent layers happened in making this decision.
no,
No, sir. I don't have specific knowledge about what the offices are that actually intervene. I understand that the only thing they do when the initial resolution has been issued, they look at the conditions of the resolution, they do translations, and they give them to the pertinent offices, but that's not within my ambit, so I really don't know in detail of what the procedure would be.
Mr. Martinez states that this is the only environmental Interpol red notice that he has ever been involved with. Truth is that this was the first Interpol red notice for an environmental crime that has ever been filed by the country.
Environmental cases that you had told me about before the lunch break, have you ever had another one where Interpol became involved?
no.
No, there have been no others in which I have been involved, in which we had to ask for an international arrest warrant because he left the country.
Here, attorney and expert witness Nestor Morera states to the contrary of what Mr. Martinez has said on the question of who could have initiated the red notice. The Interpol red notice filing was not automatic. He went on to say that the filing was very strange for an environmental crime and it must have been political.
And that is to take advantage of the witness's knowledge and criminal expertise. Would you describe for me, or comment rather, on the position that Costa Rica has taken that the red flag warning is automatic that was filed an Interpol against Mr. Aven?
No, it's not automatic. It's not automatic. Especially, it seems to be very strange that it's automatic for environmental crimes. No, it's not automatic.
So if it's not automatic, who makes the decision in order to flag someone at Interpol on behalf of the Costa Rica, if you know?
I guess it must be a political decision rather than a technical one.
So it would not be one of the environmental ministries, it would be someone from the Justice Ministry, you think?
I think.
Thank you, Chairman.
Finally, Mr. Martinez admits that he was responsible for issuing the Interpol red notice against Mr. Aven, who left the country after suffering an assassination attempt on his life.
Please go ahead, Mr. Byrne.
Mr. Martinez, relates to international arrest warrants and Interpol. Did you make the request for an international arrest warrant to be issued in this case.
Sí, correcto.
Yes, when the motion was made for default against Mr. Aven in the trial that was to start in 2014, well, together with this, we also asked or requested that this international arrest warrant be issued, and indeed it was granted by the judge.
Emails before and after the assassination attempt show that it was tied to problems Mr. Aven was having with the government. Mr. Aven was threatened that if he didn't leave the country, the next time they wouldn't miss. The U.S. Embassy advised Mr. Aven to leave the country. At the time of the second trial in January 2014, Mr. Aven was in a U.S. hospital having surgery. Although his attorney and doctor notified Mr. Martinez and the court of these facts, Martinez and the court disregarded the exculpatory reasons as to why Mr. Aven could not be present for the second trial. They then maliciously filed an Interpol red notice. Mr. Martinez's actions have directly caused Costa Rica to be sued by U.S. investors under the provisions of the CAFTA Treaty. One rogue, incompetent, and/or corrupt prosecutor is responsible for the international scandal being brought down on the head of this country today.
In January of 2014, when that hearing happened, or when Jovan was put on trial the second time, I was in a hospital in the States and had surgery within a week or so, virtually at the same time. And I sent letters from my doctors from the hospital. I sent them to Manuel Ventura, who is my attorney, and he forwarded them into the court. And they didn't care. They didn't care. And they put out the arrest warrant immediately. And the next thing I know, there's a Interpol report, and it was a total. So they just kept ramping it up. And after I looked at the Interpol report, which we got from the respondent, Interpol clearly told them, look, according to 83.1.1, I think, as I remember reading it, this is not a crime that rises to the level of reporting people to Interpol. It's like somebody steals a candy bar from a 7-Eleven and they don't show up for hearing, so you report them to Interpol. No, that's not what Interpol's for. They're for serious crimes. And they told them, I read it myself after Mr. Burns sent it to me. And they still insisted. They still tried to get tried to appeal to Interpol to get the red notice issued for me. It was it's mind-boggling. I mean, nobody can believe. I tell this story to people, they don't believe it. They think I'm kidding them when I tell them what happened.
Here, Mr. Baker asks Mr. Martinez if he would have done anything differently in retrospect.
A lot of time to think about this, as has everybody that's been involved in these proceedings. Is there anything, as you sit here with the benefit of hindsight today, that you would have done differently in the investigation or the first trial against Mr. Aven? Or would you have done it exactly the same if you had to do it all over again?
No, not at all. I am convinced that what was done in these proceedings was in strict compliance with Costa Rican law, that there was no arbitrary actions on my part with regard to the defendant. His guarantees and rights were respected, and that he was entitled to a lawyer and exercised that right at every time. I do not, my conscience is clear. I'm at peace with that, and I do not regret a thing.
Mr. Martinez, I appreciate it.
Mr. Martinez said that what was done was in strict compliance with Costa Rica law and that there were no arbitrary actions on his part. Do words and actions have meaning? Let's look at Mr. Martinez's words and actions. 1. Mr. Martinez failed to follow Costa Rica law and comply with SETANA resolutions issued in 2006, 2008, 2010, and 2011. 2. He failed to follow Costa Rica law and comply with legally issued construction permits issued in 2010. 3. He failed to follow Costa Rica law and comply with an INTA report, which was objective evidence, stating that there were no wetlands. Instead, Mr. Martinez said he didn't believe that government report. 4. Mr. Martinez failed to accept as objective evidence numerous government reports from MINI, CNAC, and SETANA from 2007 to 2011, stating there were no wetlands. 5. He was instrumental in having an unwarranted Interpol referral red notice issued against Mr. Aven, based upon his false statement that Mr. Aven was wanted to serve a 3-year sentence. 6. He filed false criminal charges against Mr. Aven and Mr. Damjanits, knowing no crime had been committed. Yet Martinez has the audacity to say that he acted in strict compliance with Costa Rica law. Do you believe Mr. Martinez? Or do you believe he is either grossly incompetent, deranged, corrupt, a congenital liar, or all of the above? We report, you decide. David Aven clearly states that Mr. Martinez and other government functionaries refused to comply with SETANA resolutions, which by law they were required to obey. Mr. Aven quotes 2 people working for the government, Mr. Jorge Briceño and Mr. Fernando Zumbado, who clearly stated in their witness statements that everything Mr. Martinez and the other government functionaries were doing was illegal.
Well, there was numerous ones, okay, and I'll tell you what I can recall.
Okay.
2004 SETANA resolution, 2006 SETANA resolution, 2008 SETANA resolution, 2010 SETANA resolution, and April 2nd, 2008 MINI clearance letter for the EV that we got in, and when I say resolution, it's an EV, okay, because once the permit is, I call it a permit, is issued into a resolution, then at that point in time, according to Julio Eduardo, it becomes a government order that everyone is required to comply with. All public and private institutions are required to comply with. And the problem, as I said in my statement, that none of the functionaries in the Costa Rica government complied with it. And we have the testimony. You don't have to, and so, okay, David Aven saying this, don't, you know, he doesn't know what he's talking about. He's, you know, but there's a guy that we got a statement from, Mr. Jorge Briceño, from the municipality, who dug deep into what was going on in Las Olas, and even went to the TAA in San Jose to do his due diligence. And this is a guy that, and you probably read his statement. And what did he say? What did he tell the government functionaries? Everything you're doing is illegal, and it even can cause civil and criminal penalties on you guys, and it could cause serious damage to the Treasury. What happened? Nobody paid attention to him. So this is not David Aven saying it. This is not George Burns saying it. This is a guy in the government saying it. If you look at Fernando Zumbado's statement, and he was an ex-president, ex-housing minister. His statement, and I knew him personally, got to know him in 2006. And I was working with him when he was a housing minister to put low-income housing down into the Esterillos area. What did they do? He wanted to run for president. So what do they do? They falsely charge him with a crime, just like they did with me, and he had to resign, and that killed his ability to run for president and also killed his reputation. What did he say? Here's what he said. This is a guy that was an ex-U.S. ambassador, ex-UN representative, two-time foreign minister and was going to run for president of the country, and they did the same thing to him as they did to me. They charged him falsely with a crime. And here's what he said in his statement that I remember. This kind of criminality has to stop, because if it doesn't, it's going to really impair the ability of Costa Rica to attract foreign investment. Now, these aren't U.S. investors saying this. These are seasoned Costa Rica dignitaries and high-ranking government officials. We follow the rules. It's like, look, what is this business about? If you follow the rules and you do the things the right way, they come along and say, oh, those weren't the rules? No. I mean, the lawyers we got advice from told us what the rules were, and we followed them. And then when we follow them, they arbitrarily come along and say, oh, that's a different interpretation. That's not what it means. So I totally reject this kind of arbitrary, capricious decision-making where they can just arbitrarily, you know, look, when governments issue valid permits, developers have to be able to rely on those permits. You can't make it a game of now you see it, now you don't. It's not a magic trick. You have to be able to rely on those. You're spending millions of dollars developing a project, and it has to be stable. You have to have a stable environment, a stable government that when you know you follow the rules, you pay a lot of money to get permits, they're not going to be yanked away by some rogue prosecutor that for whatever reason decides he's not going to follow the government law.
Costa Ricans are fed up with corrupt government officials who engage in criminality that ends up costing them both money and misery. Should Mr. Martinez be investigated for corruption and criminality that has so far cost the Costa Rican people millions of dollars? We report, you decide. There are hundreds of other examples of corruption in Costa Rica. It has been going on for years. Right now, in December of 2017, it's the Banco Costa Rica criminal scandal. Mr. Martinez is just one more glaring example of corruption that is plaguing the people of Costa Rica, and the people want it to stop.
No, not at all. I am convinced that what was done in these proceedings was in strict compliance with Costa Rican law, that there was no arbitrary actions on my part with regard to the defendant. His guarantees and rights were respected, and that he was entitled to a lawyer and exercised that right at every time. I do not, my conscience is clear. I'm at peace with that, and I do not regret a thing.
Is to stop the dysfunction that's happened in our case that's led us here. So if Mr. Martinez would have just followed the law and complied with his own law, we wouldn't be here.
Thank you, Mr. Chairman. Thank you.
None of what Mr. Aven said at this hearing was ever objected to, challenged, or proven false by Costa Rican attorneys. Therefore, all of what Mr. Aven said stood as being truth. We report, you decide.